And we are live. Hello, everyone. Welcome to the Alien Spaceship stream. You could be watching from anywhere around the country or the world. And I really appreciate every single one of you coming to you from the Spaceship Studios from a galaxy far, far away. And now what we are going to be doing is going to the other screen to talk about some different things. And let's go here. See how this goes. Okay. Alright. Greetings, everybody. It's Alien Spaceship. And hey, Duke. Good to see you, buddy. Oh no. Oh no, we're still in the game. We're still here. Okay, hey Duke. Good. It is great to see you. Glad to have you on board. And we watched a trial today that was in Hawaii, and it was a murder trial. So that trial was. I like the judge. I like the different witnesses on the stand. They were all good. Good to see you too, Duke. Yeah, they were all on the stand, and they were showing maps, and this dude tried to accused of trying to murder his wife. And if it was his girlfriend and I got that wrong, y'all can, somebody can correct me. But basically, they showed her traumatic head injury, and he like pushed her off a cliff, and they found him with a rock in his hand, and he was gonna go. People were thinking he was gonna do something nefarious. Yeah, so it was not a good scene, and in my opinion, he is extremely guilty, and his goose is cooked. I think pretty much everyone agrees on that at the trial. And let's see what this is. It's right here. No, that's the wrong thing to do. What is that? Oh, there he is. There. Okay. Oh, well, the settings are being silly, so we're just going to go there and just go that way. Okay. Now we're back to where we were supposed to be, because things are not showing me what I was supposed to see. Yeah, so I'm just getting a name here, and Konig. Okay, that's the name. And then we're going to react to the AFROMAN trial also. Okay, here we go. So, Duke, Chad, I'm going to tell you all what this trial is about. And Konig, a former Maui anesthesiologist, is currently underway as March 2026. He is charged with second degree attempted murder, following a violent attack on his wife, Ariel Konig, during a birthday hiking trip in Hawaii. We were talking about hiking on the show, and this is something absolutely a hiking nightmare to have somebody planning someone's death or a fight in this type of terrain. That is very messed up. And the incident on March 24, 2025, while hiking in Puka Trail in Oahu, Gerhard allegedly attempted to push Ariel off a cliff after she refused to take a selfie near the edge. Well, chat, I was watching this trial from right in the beginning when it started, but she didn't want to take a picture on the edge. I wonder why. Like, that's a question to ask. And you see, these people have to do these brutal murders. It's really messed up. The assault. Prosecutors state that when Ariel tried to flee, Gerhard beat her in the head with a rock, apparently 10 times, smashed her face into the ground, and attempted to inject her with unknown substance from a syringe. So, yeah, Duke, this dude was on a shark frenzy. He was, and I saw it. They showed it in the trial. I don't know if they were supposed to show it, but they showed it. It was very dramatic looking. Yeah. Hello, Fifi. Welcome to the stream. We're talking about the the trial from earlier. Shout out to you. And so the rescue. The two hikers heard Ariel's screams, specifically her shouting, "He is trying to kill me," and intervened, calling the 911. Ariel survived but suffered severe injuries, including a broken mandible and torn retinas. And I will say, for that, survival was incredible because it looked like she was either dead or near death. Like, that's really a messed up thing to go through and overcome it. So the confession, yes, it ended very early Hawaii time. So to also mention, which I didn't think I'd be doing this live right now exactly at this very moment because of the trial's timing. Because the trial in Hawaii is really hours away from the mainland. Because there's the West Coast that's still sunlight, over there. But the Hawaii's even more. It's probably like 3 o'clock over there right now. So I thought we were going to still be there at the moment, but we are not. So yeah, it ended very early at 2 p.m. in Hawaii time. And there was a confession. A crucial piece of evidence is a video of called Gerhardt allegedly made to his son shortly after the attack, which he reportedly said, "I just tried to kill Ari, but she got away." Yeah, so there you go. He that, and I believe, although I think his attorney, well, both the state, the DA, and the attorney both do pretty good the way they conduct themselves. But remember, a 666 earlier was saying that the attorney has his, his. I'm paraphrasing his script from Tellus. But yeah, it was. So I like the way the court set up, and the attorney and the DA both seem pretty uh, very professional, very professional. Everybody does. And but the defendant seems all grumpy and pouty. And the legal rulings on February 2026, the judge Paul Wong denied a defense motion to dismiss the case, clearing the way for the trial, and the judge also unsealed the salacious allegations of past misconduct for Gerhardt's ex-wife, though their 3 specific paragraphs were temporarily kept secret until the jury selection. And Duke is just tired of seeing Afro Freak's face in Fro. There is some talk about making a AFROMAN sticker in the sticker section that I have. So uh, it's definitely the outfit he has. It's going viral everywhere, and there's different people have different opinions about him. And yeah, he won the case yesterday, and kind of like was supposed to do this yesterday with React, like going through the last part of the trial. But there was some Timu Sheen. There was the Timu net went out, but I had a good phone live, got some new subs, and we had a good breakdown about the answering questions from chat about the trial. Oh, Duke says, "Now you picking on me." Oh yeah, I'm picking you like you are a bunch of jelly beans. Yeah, I'm poking ruthlessly. Yeah. Legal rulings on February. I read that. I think. Okay. Jury selection began on March 11, 2026. Trial is being followed closely in major outlets like Court TV and LC. All right, I'm going to talk about the evidence that was presented. Then we will, at some point, get to this reaction and of the closings of AFROMAN. In Konig, which began opening statements, okay, eyewitness accounts. 2 women were hiking nearby, testify that they heard Ariel Konig's screams for help. They reported seeing Gerhardt on top of his wife holding a rock while she lay on the ground, which is not a good scene. Alleged confession. A key piece of evidence is the video is Gerhardt reportedly... Okay, I am back. I'm not back. Okay, I am back. I'm not back. Okay, let's just close this window out. All right, thank you. Thank you, Duke. I am back now. I have returned. Okay, so at this point in time, we're going to go to the other part of reacting to this trial. All right, so here we go. All right, this is the defense attorney for AFROMAN doing the closing arguments or closing arguments. Oh yeah, yeah. Okay, I think with this case, it was. Well, I think it was good because the defense attorney did a good job of. People could have disagreed with him or not. The defense did a good, well with that, and the prosecution did their end, presented their case well too. There was some scenes that were, the police officers were like, some of them were upset about the rap videos, and one of the ladies got emotional about it. So they had some hot button moments, and the witnesses too. There is touchy moments, and I would say it was very interesting to watch. My chat, when we watched the different parts of it with chat, the chat was very engaged and diverse opinions about it. So I think that it was a good case to watch, and there's diverse opinions about, if which side was right or not, because it's a very, touchy subject with the free speech. So here we go. This is the closings. All right.
On what was going on in their lives. Their personal effect, the personal things happening to them, combined with entertainment, which unfortunately is exaggeration. Opinion, nothing of fact in that song. It's a commentary on society. And so when you look at rap, you see that over and over again. I had my secretary print me a couple songs, rap songs, while I was pouring a cup of coffee. And the first one is Carly B, WAP. I find it bad to say what WAP means, but it's a popular song. I think it's somewhat derogatory, but then again, I'm not the audience for that song, and I know that. I know nothing in that song. Nothing talking about is true. I know it's entertainment. I know it's social commentary. Miss Grooms testified even her students knew that at a young age. The same thing I knew when I was watching Johnny Carson, The Late Night Show, and SNL, Saturday Night Live, with my grandfather when I was a kid. That's all entertainment. They make fun of everybody for entertainment. And some of it is a social commentary. But it is not fact. And everybody knows that. Nobody looks at Lil Wayne's song Pussy Monster and says there's a monster in that song. Everybody knows it's exaggeration for entertainment. Is he commenting on something? Sure. But it's not fact. And I can keep going. Megan Thee Stallion with sex talk. I mean, it just goes on. They use derogatory language. It's designed to entertain. Drew Hastings, former mayor of Hillsborough, was a comedian. I got to go to one of his stand-ups. Some of it was funny, some of it wasn't. Some of his jokes, like those of Eddie Murphy and Richard Pryor, some of them are not tasteful, but they're still jokes. They're not facts. And we know that. That's what a reasonable person listening to that would understand. And that's the point. This is not a vacuum. We don't live in a vacuum. Let's face it, if we lived in a vacuum, we'd all be dead because we couldn't breathe. So we live in a world full of everything, where we see things. We watch SNL. We know it's entertainment. We know it's going to pick on people. We understand that they're picking on public officials. Well, they picked on Joe. They pick on Donald Trump all the time, Sleepy Joe. I mean, go down the list, even Teflon Ron was made fun of. So as you go back, nobody thinks that's fact. Nobody's going to take it that way. When they post their clips on YouTube, when they post their clips on Facebook, people don't look at it and go, that's the truth. No, they understand it's comedy. They understand they're going to talk about it going forward. And if you look at his posts, you see the little signs of that too. Iteration. Things that you see in a song. I mean, because after all, you know, a song's catchy, right? It has a beat, song, you know, words rhyme. You know, she thinks my tractor's sexy, and, you know, it sticks with you. When we listen to Lemon Pound Cake, you heard the iteration. You heard how it came together as entertainment. So we don't exist in a vacuum, and a reasonable person doesn't exist in a vacuum. As the judge has said, you are a reasonable people. You get to decide what's reasonable, which means you get to use your experience. You get to use...
Hello, Moki. Welcome to the stream. Oh, and hey, Lori. Also, shout out to y'all. And Chat Fam was watching last night's Garden stream replay. Oh, okay. Thank you for watching the replay. That was a cool stream. It was good. We talked about all kinds of stuff and UFOs and people were saying and different fishing stuff. It was really, really interesting. All right. And yeah, I thought we would still be watching it too. Yeah. Definitely. I thought we were still going to be watching it from all the way this time. Yeah. But they ended at 1 o'clock over there. Hope you enjoyed your meal earlier, Moki. I'm sure it was nice. Okay. Yeah, because that's wild, that trial. It's very late.
Use your understanding of what those are, of your understanding of Joe, of your understanding of rap music, music in general. I'm not going to sit here and say that these 7 people were happy about what happened to them. I'm not going to say that. That'd be stupid.
Knock on wood about that, Lori. The earlier with TMUNet, there's parts of the year sometimes it will have problems, which I don't really know what the reasons are exactly, but they happen every so often, not all the time. But today, earlier, around the time of lunch break in Hawaii, I was over at at family's house to get have the internet a reboot for a little while. So last night when I did it right before I went live, and it may have just had a problem anyway, but I wanted to do it hours ahead where it could completely get itself together, configure it all together before I did it. And so far, we're here at the moment. Thank you for asking. It was nice seeing family today. It was, the way it works is the internet modem's in the middle of another house next door. So there's this other extender thing that from there that goes over here. So it's a long range, but it's designed to come here. But as I said, sometimes for various reasons, I was doing some AI things. Maybe that was causing it to go down because it was a big file. It was kind of like a big file. So I don't know what, but this has happened for years. It does this sometimes. But yeah, so far we are here, and I watched the trial earlier. So that to answer your question. Lori, Moki, everyone that's coming in. I hope everyone had a good day, and thank you all for being here as we watch this AFROMAN closing.
But what I am going to say is, they are public officials. We see it on the news all the time, public officials made fun of. Let's go back to voir dire. During my voir dire, we talked about, with the one juror that's gone, we talked about that, yes, I ran for public office. She agreed I put myself out as a public official. She agreed that it was an opinion when someone called me a baby killer. Even our witnesses on the stand, I asked that question. They said a crooked defense attorney is not a vine, it's a matter of opinion. Crooked cops, dirty defense attorneys. Oh wait, one witness did want to say I might not have taken a shower. But those are all opinions, exaggerations, not statements of fact. And we know that. And that's why public officials
Yes, absolutely, Lori. Facts.
are held to a higher standard, because that standard is what is expected of them as subjecting themselves to public scrutiny. They all testified that people have criticized their work. I mean, after all, we look at the search. There is, even Mr. Newland admitted it wasn't perfect. I think we can see from how the money was handled, the investigation. I would have liked to have seen a more thorough job myself. I mean, we have a chain of custody, the money that just leaves it laying there. Mr. Newland didn't know that. We have an unsealed evidence bag. We have 10% of all evidence, money evidence in the Adams County evidence locker miscounted. And then keep in mind that that miscount on those is less than what is alleged to miss here. We got people saying we had a miscount, yet they can't even bother to notify the court in an official document that they made a mistake. Just let it ride. As far as the public record knows, which they never corrected, Mr. Foreman never got back all of his money. They want to talk about an investigation, but they can't even put in a single piece of paper to correct his mistake. I don't know if I call that lazy or what, but I think it goes to what you consider a fact. Because what is a fact? We can't always know what a fact is. A fact is something you can disprove, right? But can we truly disprove that? Looking at all the evidence, there is questions. If there's questions, it's not a fact. Now, people will form opinions based on that. I formed an opinion. I imagine everybody here's formed an opinion. We know that they formed an opinion because they didn't like being called a thief. So that was their opinion. But people are allowed to have opinions. People are allowed to express them. What people are expressing when they call them thief is not a literal statement. It is not a fact. It is a social commentary on the fact that they didn't do things correctly. And they can't even articulate how they could fix it. That is a social commentary if I ever heard one. They don't like it? That's not their choice to like it or not. They're public officials. They're going to be held to a higher standard. Their work's going to be criticized. I mean, that's just what happens when you're a public official. No reasonable person would expect a police officer not to be criticized. They've all been called names before. Has it affected them personally? Yes. Miss Grooms testified it made no difference in her life. Her kids didn't take it seriously. And she's taught for damn near 30 years. But they seem to take it seriously. And I come back to Mr. Grooms. He's worried about going out on a call and being shot. Now, maybe I'm old-fashioned. But if I'm going out on a call, I'm worried about getting shot, I'm going to call my wife and tell her to be safe. Not sit here and go, I'm worried about me. That's not what you do. You take care of your family. Mr. Walters wanted to point that out. That just goes to show us he didn't take it seriously. Now, I'm not going to say they're not afraid. Anytime they go on a call, the highway patrol will tell you scariest thing's a traffic stop. You know nothing about the person. You're there by yourself, and things can change in an instant. Is that scary? Fuck yeah. I'd be scared. But If you're truly scared, you take the steps for it. You start having your family do stuff. You start doing that. If you believe what you're saying, you take the steps towards it. You didn't take the steps. No one else talked about how they took the steps either, did they? And why does that matter? Because a reasonable person is going to look at that. After all, let's go back to me not taking a shower. How would you know I didn't take a shower? Hair clumpy, probably matted, probably got dirt all over me. That's how you would see. That's how you would prove if that's an opinion or fact. Now, even then you might say Dave just fell in the mud. But no reasonable person would take it in the vacuum. And I want you to think about everything in context. What rap is music, how it's entertainment, how the language works on it, how jokes are made. I want you to think back to that, because that colors how you see it. I love picking on Joe. He's a good sport for it. Look at that suit. Does this look like a man who thinks that everybody's going to assume that everything he's saying is fact? I mean, he's like a comedian. He exaggerates for the sake of entertainment. That's who he is. I'm not going to say it's tasteful to everyone, but some people do find it entertaining. I asked an important question about them. I said, do you believe everything in the newspaper? No. Do you believe everything you read on the internet? No. We all know that to be true. A reasonable person knows that. People can post opinions, social commentary, and hurtful things all over the internet. And it is just to be expected. That's why we are supposed to use our own filter, use our common sense, use our experiences in life. So while hurtful, it was not fact. It was music, entertainment. Stuff that no reasonable person would understand. Especially not a public official, because we see it on TV all the time. We see it on the internet. You see it on Facebook. Sometimes people want to turn off Facebook because there's so much political commentary and stuff. But that's expected. Do I expect everything I read's fact? I don't even think most of it's fact. I think it's everybody's opinion, and opinions are like assholes. Everybody has one and it stinks. But that doesn't mean they can't have them. That doesn't mean they can't express them, and that doesn't mean they can't make a song about it. Truth is a defense. That's why we talked about the theft. That's why we showed all that. Because I wanted you to see how the money was handled. There's a lot of confusion around it. And for that reason. Before I get to another point, I want to address something that's bouncing around my head. Bob says, what does this message send if you find for Mr. Foreman? I rephrase that question a little differently. What does this message send if we find that music and social commentary, while maybe not the most tasteful thing in the world, is silenced because a public official, while hurt by it, yes, unhappy by it, yes, pissed off, yes, emotional, yes. What opinion does that sound? I mean, if you can sue people, music artists, comedians, to shut them down, that's what we're looking at here. I'm sorry they feel the way they do. But there's a certain amount that you have to take as a public official. It's part of the duties as a job. As we talked about during voir dire, as I've talked about them being called a baby killer, there's certain things you take and you move on. It's part of the job. The plaintiffs, or I should say Bob, talks about how they wanted it to stop. Where was the certified cease and desist letter? Where was all this done? None of that was done until after they started the lawsuit. Until after they brought it to court to make it stop. That's what they wanted to. They wanted to make it stop. Yet they asked for money. The commentary on them is nebulous at best. You can see that. when you look at it. We have Beetle Bailey, Gomer Pyle, Colonel King Kong Bundy. Some of these names are not as bad as others, yes, but they're all for artistic purpose. They're all for jokes. They're all for entertainment. This is not to paint them in a real life. No reasonable person would think that. It's kind of interesting because even Mr. Newland agreed that when he was called a pedophile by Mr. Foreman, yes, that is a horrible thing to call a person. But even he said it was Mr. Foreman's opinion. So he didn't believe it was a fact. If your own witness doesn't believe it's a fact, how can a reasonable person find it's a fact? Bob went to great lengths to say nothing will stop him. Shows us where we're at. We got to stop his expression. We got to stop entertainment. We got to stop exaggeration. That's what Bob's talking about. What chilling effect does that have on the world we live in? Think about it. You don't like what a commissioner does. You don't like what our prosecutor does. You don't like what any public official does, and you make a joke, and you're drugging the court. It may not have been a tasteful joke. May have been a bad joke. May have been the greatest joke ever. But what we're saying is if they don't like it, we're back here. What does that say to freedom of speech? What does that say to the world we live in?
Thank you, Regina. Nice dono. I appreciate it very much. Alien Spaceship, this is for you. Ah, okay, thank you.
That's what this case is about. And Bob knows that. That's why he mentions it. That's why when you look at defamation and the jury instructions, you'll see that the first element of it is a statement. Portrayal of fact. Has to be portrayed as fact. No music video portrays as a fact. I don't watch Fuck Those Police and turn around and say, you know what, that's a fact. No. I say that's a song, it's entertainment, and move on. Sometimes I try to figure out what the words mean, what kind they're getting at, but I don't expect them to present a fact. Fourth element is the proximate cause. It's an interesting question there, because you'll get the definition of causation in proximate. And we never talked about that really during the trial, and it's going to be something that I want to discuss. They talked about getting phone calls. None of those posts. Joe never said, call them and tell them this. Mr. Cooley testified that they mailed pound cakes to the office. Joe never said send them a lemon pound cake. These are things that other people have done. Joe never directed them to do it. He didn't cause it. He made a joke. He cannot control how people take it. What they do, he's not that. All he can do is make a joke, make a song. So that's something to consider. Was he the proximate cause, or was it someone else? I want you to understand when they get to the question of malice, if you get that far, it has to be actual malice. Public officials, it's a higher standard. Why? Because we hold public officials to a high standard. Let's talk about the false light. That's their second cause of action. That says that a reasonable person would be justified in the eyes of the community, feeling seriously offended and aggrieved. I want you to go in on the eyes of the community. They want to say people's humiliating them, calling them names. The reality is a reasonable person in the eyes of the community is going to say, it's a song. It's a joke. I was flabbergasted to hear it myself, that they even thought it was a joke before they brought the lawsuit. Go to a Halloween party and bring a lemon pound cake. That, I almost have no words for that, honestly, because I get, we're hurt, but it's a joke. Which one is it? So a reasonable person in the eyes of the community would understand it's a joke. Mr. Estep testified about the joke of the shirt. We got the pound cake joke. There's various jokes for this. This was not as negative. This has not changed their view in the eyes of the community, because your reputation, which is what they claim is hurt, your reputation is like a shirt. You eat a hot dog, you drop mustard on it, you get stains on your shirt. Nobody's reputation is clean. Everything you do affects your reputation. The way you perform your job affects your reputation. They all admitted to that on the stand, because I asked that question. They all said it does. How they counted that money affects their reputation. People can form opinions based on how they did their job and criticize them on it. That's a right we have. You have to forgive me, I have to flip through these some. We didn't have a lot of time to prepare as things change on the fly. I think as you go back and deliberate, take a look at all the exhibits, analyze it in the context of music, entertainment, opinion, social commentary. It's not a fact. And if you look at it, you can see that. Like I said, it may not be tasteful, may not be nice, but even SNL is not nice. South Park's not nice. These things are social commentaries, jokes, entertainment, and some of them are not nice. But you don't have to like everything. You don't have to like everything said about you, and you don't have the right to tell everybody that everything said about you should be sued for, especially if you're a public official. As such, I ask you to deliver a verdict in Joe's favor on all claims. I ask that because when you look at it, no reasonable person could see it as a fact. No reasonable person could see it as even false light. The community, if they called them, if people called them, that's because the social commentary resonated with someone, resonated with what people experienced in the world. We've lived through a turbulent year, so we've all seen on the news what people are experiencing all over the country. Social commentary resonates because of that. That doesn't make him the proximate cause. That shows a deeper concern in our country that we should be addressing, not sitting here trying to decide if a music video is a fact or not. That's what's at issue here. And I'm confident as you go back in deliberations, you'll come to that conclusion too. And with that, I thank you again for your service, because it is not easy, and what you're about to do is not easy. It takes time and deliberation. It takes hard work. And I appreciate that you guys are willing to do it. And I reiterate again, that's what makes us a great country. Thank you very much.
Mr. Osborne? Go ahead, Mr. Flanagan.
Thank you, Your Honor. Nothing Mr. Osborne said about sexually explicit songs out in society refer to specific people in the community, like the songs that are at issue here. It's not the same thing. We all know that. These weren't opinions. Mr. Foreman didn't say, in my opinion, Brian Newland is a pedophile. In my opinion, they're all thieves. In my opinion, I fucked his wife doggy style. He said it like they were facts. And I think Judge Hine is going to instruct you, based on everything that's happened so far, that these were not opinions, They were stated as fact. And your job is to decide whether those facts were true or not. And we know they're not. The case isn't about lemon pound cake. It's about intentional lies designed to hurt people, and they hurt people. If somebody in the jury room says, well, what about his First Amendment rights? You know, and the law tells you, that doesn't allow lies that hurt people. If someone tells you it's just artistic expression, he ought to be free to say what he wants, the answer is he's not allowed to wrap up harmful lies into songs, so-called art, put them out there, and get away with it. The packaging of the lie doesn't make it okay. The message was clear. And Mr. Foreman doesn't get to wrap himself in the American flag and say, you can't touch me, I can say what I want, no matter how untrue it is, no matter how much pain it causes people, no matter for how long, because I have freedom of speech. He can't do that. I'm confident you'll tell him he can't do that. Thank you.
Thank you, Mr. Flanagan. Let me acknowledge Mr. Osborne.
Your Honor, I didn't mean to interrupt you. My thing is, I was going to ask before we read the jury instructions if I could if we could restroom break for that, because I know it's going to take some time to read them.
Everybody's going to stand in their seat and stretch. Nobody's going to leave the room but you. Because you're pretty prompt with that, so go for it.
Thank you.
I'll just stand up. Blood flowing.
That was true.
Well, you're on my team.
Yeah, so the argument here would be that so a better thing that could have been said was that with his rap song could have done something where, maybe calling one of them a pedophile, that type of stuff, maybe going a little bit overboard that may have caused more harm than good. That's basically the counter argument about this whole case, what they were trying to sue him for. But people could dispute if the suing him for that much or not was the right thing to do or whatever. Just as AFROMAN's attorney said, it's all a matter of opinion. And one thing that the DA was touching on was a freedom of speech argument, which he could have said something differently about. Like, the freedom of speech is allowed, but the idea was the way he did it in a certain way could have caused more slanderous things in some of the stuff he said, but at the same time, people would have a freedom of speech. But what this guy does is he was talking when the prosecution was closing. He was talking about speech that is hurtful, that will harm people. He could have, because what the AFROMAN's attorney was saying, that the freedom of speech, even if you like it or not, it's protected by the Constitution. But the argument isn't even about the Constitution, which I'm not. The argument is about not about the Constitution, but about if what he did was going a little bit too far or not. That was the thing that was being discussed. So, yeah, I believe that his attorney, AFROMAN's attorney, did very well. He did excellent. I believe he's a streamer. From what I read, he's a streamer, and he was in the high profile case. So, yeah, and there could be lessons to be learned if people do the rap songs. They, as I said, can, if it really was like like police officers, they're trying to do their job or what they're told to do by the top, and they, like, the argument would be that besides the case about the suing thing, but besides that's like, I'm not talking about that, but like they didn't want like police officers to be afraid of doing their job if they have to go do something. And I will add that what happened here with AFROMAN, as we talked about yesterday, is somebody tipped them off that he had people in his basement and he was drug trafficking, and like he's basically like Diddy. And maybe they could do something where they could have more evidence or proof about something before raiding someone's house, because it happens to people online, and in general, it's not something anybody wants to happen to them. You say they have, someone held hostage and they have to go break down the door. Yeah, but at the same time, the police officers were trying to do their job. So those are just kind of giving you both sides about what both arguments are saying. And it's important for the prosecution to convey the information about his opinion about the case. But what the attorney did, what AFROMAN's attorney did, was talk about the First Amendment rights. This was a trap for the DA to harp on that instead of the actual case. That way, the jury saw that the AFROMAN side, they believed, was not guilty. So, of defamation. So that was he put the DA in predictable patterns of response. And that is what happened towards in this case. Thank you, chat, for your thoughts on this, and we are continuing. Let's go to this part right here. We're going to just kind of go to the next part. Oh, here we go. Let's see about this.
And the court refines the instructions to account for the conduct of the trial. So to the extent that they might have gotten the instructions very quickly this morning, it's not that they didn't know it, it's the refinements, the little tweaks along the way. That's what they're talking about. But I want to thank them because they did good work making it possible for me to get to the point where I can give these instructions to you. The court has the legal duty to prepare the instructions of law. You've heard the attorney's statements, arguments, you've heard the evidence from the witnesses. The court's duty is to instruct you on the law. And then you have a legal obligation to accept the instructions the way they're given to you. It's your sworn duty to do that. You cannot apply what you think the law ought to be. You're obedient, as I am obedient, to the rules of the law. A person who claims that certain facts exist, in this case the plaintiffs, have to prove them, in this case, by what's called the preponderance of the evidence. You've heard me say this before. I'm going to try to go over things but the obligations are called the burden of proof. Plaintiffs have to prove their facts by a preponderance of the evidence. Preponderance is more evidence in favor of their position than opposed to their position, tilting the scales in their favor. There's one element that has a different burden of proof. Clear and convincing evidence, a higher amount, a greater weight of evidence, has to be proven with regard to the knowledge or the motive for publishing. But generally think, okay, can the plaintiffs prove their case by slightly more evidence in their favor than evidence opposed to them? There's two claims, what we've called defamation and, secondly, false light invasion of privacy. In your deliverance in their favor than evidence opposed to them. What we've called defamation and, secondly, false light invasion of privacy. But generally think, okay, can the plaintiffs prove their case by slightly more evidence in their favor than evidence opposed to them? There are two claims, what we've called defamation, and secondly, false light invasion of privacy. In your deliberations, each of those claims is deliberated separately because there's separate rules for each. I'll give you more. But there's separate law for each of those separate claims. There's 7 plaintiffs, each of whom is entitled to their own deliberation. So when I refer to plaintiff or plaintiffs, what I'm saying to you is that side of the room, but you always have to apply these facts individually and separately deliberate each person's claims. If you rule in favor of one plaintiff, it doesn't mean you have to rule for all the rest of them. If you rule against one plaintiff, it doesn't mean you have to rule against all of them. So it's not like an all or nothing verdict. It's 7 deliberations. And I'll use plaintiff and plaintiffs interchangeably, just understand the analysis and what I'm trying to communicate to you. So to go back to burden of proof, preponderance is the greater weight of the evidence, evidence that you believe outweighs or is overbalanced by the evidence opposed to it. A preponderance of the evidence is evidence which is more probative, more probable, more persuasive. It has greater evidence value to you. Look at the quality of the evidence, not simply the quantity. If it was only about quantity, there would be more plaintiff witnesses than defendant witnesses, so you'd think, oh, just because of the number of witnesses, someone must prevail, when in fact you look at the quality of the evidence. Don't get hung up on which side called the witnesses. Think about the quality of the testimony, what you took from it, regardless of numbers, regardless of where it came from. If it would turn out in your mind that there's an equal balancing, the evidence opposed to it and in favor of it are equal, then the plaintiffs have not met their burden of proof because they didn't tip the scale slightly in their favor. If you could decide a fact or an item in 2 different ways, you have to decide it based upon the facts, not guesswork or coin flips or I don't care. So in those areas where it's hard or it's difficult to resolve, you have to resolve it. You can't leave it up to I don't care and I'll just flip a coin or it doesn't matter. Guesswork's not what you're expected to do. The heavy work of sorting out the facts and deciding which side of the scale they go on is the role of the jury. Now, when we talk about preponderance, slightly shifting, we also have to talk about clear and convincing evidence, a different standard for that one element of motive to publish. Clear and convincing evidence is a higher or greater amount of evidence. You have to be more convinced. Clear and convincing means the evidence produces in your mind a firm belief or a firm conviction that that item is true. So preponderance might be, by example, slightly tipping the scales. Firmly convinced is more convinced, greater evidence offered by the plaintiffs with regard to the motive or the knowledge of publication. What's the evidence of trial? Evidence is testimony and exhibits. Evidence is direct and circumstantial. People scratch their heads on this, but it makes sense later. Direct evidence is when a witness has an opportunity to see or hear those things about which they testify. I sat here, I watched the jury take their notebooks and write in their notebooks. Direct evidence, an eyewitness. Circumstantial evidence is different. Circumstantial evidence is when you look at the facts and circumstances surrounding something you saw, and then you make a conclusion that something else actually occurred. I saw the jury box empty, I saw the pencils, I saw the notebooks, I saw the end of the day. The notebooks were all open, there were words written there. So it's circumstantial evidence that the jury took notes. I didn't see you take notes. But from the facts and circumstances that I did see, it's a reasonable conclusion of fact that you did take notes. Why do I tell you that? Most evidence came at you both directly and circumstantially. things that I personally saw, and then things that happened as a result of what I saw. Circumstantial evidence is fair game as much as direct evidence. Direct evidence isn't better. You might think it's better when in fact it's not always better, because the witness didn't tell you that they were blind when you thought they saw something, or it was foggy, or the lights were bad. So when you think about the evidence and how to weigh the quality of it, what a person saw, what they heard, what they personally experienced is good evidence, direct evidence. But so is the circumstances around that testimony. They're both fair game. Often people infer that something exists based upon the circumstances and inferences. I inferred it's a reasonable circumstantial evidence that you wrote in your notebooks. That's fair. But I'm not allowed to infer because you took notes, therefore you also did something else. You can't stack an inference that something else occurred on top of something else you thought occurred, on top of something else that could have occurred. The idea here is what we call remoteness. It gets more and more unreliable the more remote you get from the first circumstantial evidence. If you want to say the circumstantial evidence is reliable, great. If you want to infer that that's reasonable, great. But don't stack another, well, now I suppose something else happened, and if that happened, then something else should have happened. It's stacking, it's called remoteness, then it gets unreliable. With regard to the exhibits, you saw exhibits, there was testimony related to them. Consider whether the exhibits are in fact what they're portrayed to be. You decide what weight, if any, the exhibits have to have when thinking about the testimony involving them. Exhibits in video can speak themselves, but sometimes paper and other exhibits don't. So you have to consider what the witness said in light of how the exhibit was portrayed. Don't make inferences or conclusions based upon the number of exhibits. Remember, I want you to look at the quality, not just simply the number. Like theoretically, the plaintiffs had more number of exhibits than the defendant. Don't care, don't count numbers. Look at the quality, make the content important. You'll have like physical, tangible paper exhibits back there. When you get to the video or the data-driven exhibits, you'll have a computer back there so you can use that to look at the exhibits. So if it never works that way, so I always offer the bailiff services that he can come back and, as you saw, make the technology work. So if you struggle back there with plugging in a thumb drive and finding the drive and then turning it on, we would expect that. I'll tell you how to communicate with us, but just ask for help. We'll send back a very capable bailiff and he'll save the day. Evidence is not what the lawyers say. You heard opening statements, closing arguments. That's not evidence. It's helpful, it's necessary, it's built into the system, but it's not evidence. If a statement was asked and the question was not answered, there's no evidence from the question. I did that once or twice to show you how it works. Just, you might have thought the answer was going to be yes because the witness was shaking her head yes. The witness is, yeah, I understand the question, and the answer is no. So you can't use body language to get an answer that wasn't spoken from the record. I don't think that happened too often. But remember where the evidence is. It's the exhibits and the witness statement, not the lawyering side of the case. There was times where I sustained objections and handled the lawyers the way I thought was necessary. I always ask people to apologize or accept my apology if you thought how I handled the lawyers is any kind of a comment upon the quality of the case. Like, I try not to do that. But you might misunderstand that in scolding a witness or handling a lawyer, I was expressing an opinion. I love it when you guys show up because I don't have to decide. It's like I always try to make sure I'm neutral in my facial expressions and my voice tone, but sometimes I just don't get that done. An important role for the jurors is to weigh credibility. Credibility is assigning believability, assigning weight to the evidence. assigning weight to the witness testimony, assigning weight to the exhibits. When you weigh evidence, you're basically deciding truthfulness, and as odd as it sounds, it's what we do all the time. We weigh credibility continuously each day. In weighing credibility, you should consider the appearance of the witness on the stand. Consider the manner in which they testified. Did it seem straightforward? Did it seem honest? Did it seem evasive? What did it seem to you? So you're using your eyes and you're using ears to weigh credibility. Think about how reasonable their testimony was in light of the subject matter of the trial. Consider education, interest, bias. Consider if they were frank with you or not. We use these tests every day to decide whether we want to rely upon or find a person believable or not. As I told you before, every witness took an oath to be honest in their testimony. The oath does not bind you that just because they're talking, I have to believe it. In fact, you have to parse it out, because people could very honestly get up and say, I believe this to be true, when in fact they're misunderstood and wrong, not lying. So recognize you can parse the evidence. You can believe everything a witness said. You can believe nothing a witness said. You can pull out the pieces you think are credible and ignore those that you think are not credible. And then you shuffle that entire deck with every witness along the way. As a rule, we want people only to testify, general rule, about things they heard and experienced and saw, first-hand testimony. So that's the general rule. But then we violate that general rule because we let people express their opinions about what the facts or circumstances mean that they experienced. So in deciding what their opinion means and how you weigh their opinion, you do the same thing. You're allowed to hear their opinion. It's evidence. But you have to, again, parse it out in terms of the credibility test. A person can give you an opinion, and you might go, I don't believe that because that's not in their subject matter. Or they don't have enough knowledge. Or their emotions got the better of them. Or they have an interest or a bias or whatever. And you might go, no, it's a completely valid opinion because of whatever credibility factors you have. So we give you direct testimony, we give you circumstantial, we give you opinions, and then tell you to weigh out those things that you find believable, credible, and otherwise. In this process, the jury sits around as a committee. And it might be that you find a person credible, the other person finds somewhat credible, and the other person finds not credible. Expect that to happen. And then resolve those differences back there. There's more about that later, but in this whole deliberation process, that's normal. Somebody said while they were here, yeah, I'd served on jury. No, it wasn't easy. It's not meant to be easy, it's important. I just have to explain the rules enough and then tell you don't get your feelings hurt when you get back there and begin the discussion. The instructions I gave you so far would be relatively common in most trials, because those are general rules for how to do the job as a juror. The next set of instructions in the middle I call substantive instructions. These are the law that applies, the rules that apply to this set of facts, these claims. You'll have sets of these instructions to go back over, so I have to read them to you in the party's presence, but you're not expected to remember all this. You'll have your opportunities to go back over it and get schooled later. So these are the substantive instructions. Again, two claims. One's called defamation. The other's called invasion of privacy based upon this false light publicity. They have separate instructions. I put them right next to each other. But the rules for the one claim are not the same as the other. There's overlap, but they are a separate set of rules. So don't apply the rules for defamation to the false light publicity claim, because you went across the line of their two separate causes of action. With regard to defamation, each plaintiff claims the defendant defamed him or her that then caused them damages. To establish defamation, each plaintiff must show that a statement, that could be oral, written, video, was portrayed a fact that was published. So the statement was made, or statement of fact was portrayed and published. Second, that the statement was untrue. Third, that the defendant acted with malice, actual malice, or reckless regard for knowledge of the truthfulness, and that they suffered injury. I'm going to break those four apart. Okay, so again, the statement was portrayed as a fact. It has to be published, so that's all rolls together. That the statement was untrue. The defendant acted with either actual malice or reckless regard about the truthfulness of it, and then that caused injury. Plaintiffs are considered public officials. You heard a lot of that. So that's where the clear and convincing evidence standard applies. So what you're doing is taking on the element of the defendant acted with malice or reckless disregard about the truthfulness of it. That's the higher clear and convincing proof. So on that element, it's not just a preponderance. On that third element, it's thoroughly convinced about his motive for publication. Clear and convincing evidence means you're thoroughly convinced about the truthfulness of motive for making or publishing the statement. What's actual malice? This knowledge in the publication. Actual malice occurs when the defendant makes a false statement with knowledge it's false. The second part of that test, it's either published with actual malice or published with a reckless disregard about the truthfulness or not. So reckless disregard means that a defendant acted while aware that the statement was probably false, or that the defendant entertained serious doubts about the truthfulness and didn't inquire. The defendant's failure to investigate may be considered evidence of reckless disregard or evidence of falsity when the defendant had serious doubt about whether it was truthful or not. So actual knowledge of falseness or reckless disregard about something that's probably false. Those elements have to be proven by the higher amount of evidence. A statement is false when it's not substantially true. It's substantially true when the essence of the statement is true, when you think about the statement as a whole. The defendant's statements or portrayals must be given their ordinary meaning in that context, in that circumstance. So you can't just pull a line out. You have to look at the whole portrayal of the statement. In deciding whether the statement is false, you're not to consider the defendant's subjective belief. You consider whether it's true or false from an objectively reasonable perspective. So it's your perspective about truthfulness, not what the defendant thought at the time, because we can all think of things that are unreasonably thought. So we apply an outside standard, an objective standard, not the defendant's subjective belief. Now, this idea about the concept of truthfulness is where we find the fact that truth is a defense. So if the statement is true, then there could be no defamation. Plaintiffs also have to prove that the statements were published, portrayed, made. Published means that the statement was read or heard by another person other than the plaintiffs. From the testimony, as a matter of law, the courts just determined that publishing or portrayal is not an issue. But nobody pushed back. It's not anything you have to decide. I'm telling you as a matter of law, that element is uncontroverted, that the defendant published, the defendant portrayed the statement. So of those four, one's been resolved by the court because there's no contrary evidence. Now you're down to analyzing those three statements, elements, if you will. You need to know how to differentiate between facts and opinion. In a defamation claim, this is important. This is over on this side of the first claim, fact versus opinion. The distinction between portraying a statement of fact and portraying a statement as opinion is crucial. It's an important distinction. Portraying a fact or portraying an opinion. Only statements of fact can be the basis for a defamation claim. Statements of fact could be untrue, which is the nature of a defamation claim. If I'm expressing an opinion, there's no way to decide whether it's true or untrue, so you can't defame someone in expressing an opinion because there's nothing verifiable about it. It's an opinion. So a defamation claim has to involve an untrue fact. To determine whether a statement is fact or opinion, you apply these 4 factors in their whole text. You look at the specific statement, the language in the statement. Consider, importantly, whether that statement is verifiable or not. Then apply the general context of the statement, and then think about not only the context of the statement, but then the broader, how the statement could be received or heard. Start with the statement, is it verifiable? Consider the circumstances of the statement in its context, and then go farther out to the statement's circumstances in general. Look at the precise wording. Determine whether a reasonable hearer or listener would view the words as portraying fact or portraying opinion. If a statement is made and it's considered an opinion because it's not verifiable, there could be no defamation. If a statement is made and it contains verifiable information, then it can be the subject of a defamation claim if the verifiable statement is untrue. If you find that the statement was portrayed to the public as a fact, that the portrayal was false, it's a fact and it's false, plaintiffs have proven their case. If you find that it's not a fact, or that the fact was true, then the defendant prevails. This is why I give it to you in writing.
Okay, I forgot about that.
General instructions for defamation are done. Those rules apply to that claim. These rules apply to the invasion of privacy false light claim. There's only one place where I'm going to tell you to overlap the instructions. So don't overlap all the first instructions in the second bucket, separate set of rules. The person who invades the right of privacy of another person can be subject to liability and the harm that comes from invading that other person's right of privacy. The right of privacy is the right of a person to be left alone. It's the right to be free from the unwarranted appropriation or the exploitation of a person's personality or their private affairs in such a manner as to outrage or cause mental suffering, some sort of shame or humiliation to the person. Each plaintiff claims the defendant violated his or her right to privacy by publicizing false information that places them in a false light in the public. Each plaintiff must prove that the false light in which they were placed would be highly offensive. It's a highly offensive place to a reasonable person. Not their subjective, but would a reasonable person find that they were put in a highly offensive place. And the defendant had knowledge of or acted with reckless disregard to the falsity of the publicized matter. Reckless disregard, falsity, and actual knowledge are the same definitions from the first section. So that part of the first instructions you can carry over. Actual knowledge, reckless disregard, and falsity, I'm not going to redefine. That part you would read over. But it's a different test. Was the particular plaintiff put in a false light by the false information? False light means the defendants know that the plaintiff, as a reasonable person, would be justified in feeling seriously offended and aggrieved by the publicity, seriously offended and aggrieved by the publicity. The plaintiff's privacy is not invaded when it's an unimportant statement that's made. It's only when there's such a major misrepresentation of the plaintiff's character, history, activity, some fact, that it might be reasonably expected that a reasonable person would be highly offended. Determine whether the statements made by the defendant would place a reasonable person in a position of false light, not merely whether the plaintiff believed they were in a false light. So this is the objective perspective that we use for juries. You're the outside public looking in. Do you consider it reasonable or not that they would be highly offended? It's not their subjective belief, it's the public's perception. To be highly offensive, the plaintiff must be justified in the eyes of the community as feeling seriously offended and aggrieved by the publicity. The statement must be such a major misrepresentation of their character, of their history, of their activities, of their beliefs or facts about them, that they would be seriously offended in the eyes of a reasonable person of the public. False has the same definitions I gave you, not substantially untrue. The fact versus opinion distinction doesn't apply from that, so you don't have to do the fact versus opinion analysis. If you find that any one or more of the plaintiffs proved all the elements of false light, invasion of privacy, then you would enter a verdict in their favor. If you find that any one or more of the plaintiffs did not prove all the elements of false light, invasion of privacy, then you would rule in the defendant's favor. I'll say it again, there's 7 determinations on false light, there's 7 determinations on defamation, and you make them separately. If you find for a plaintiff on either one or both of their claims, then you go to the question of whether the defamation or the invasion of privacy caused damages. There always has to be a connection between the false statement and the damage, or the false light offensive position they were put into, and the damages. A person who seeks to recover damages must prove not only that the other party caused the harm, but also that the conduct proximately caused them injury. Proximate cause is an act that in its natural and logical sequence caused the injury. There was an example of the defendant could have caused, but was something else actually the cause. You have to sort out whether the person's injury came from the defendant's conduct or came from somewhere else. With regard to damages, the purposes of damages are to compensate a plaintiff for injury to their reputation, for any kind of monetary loss, for emotional distress, so it's compensation, to vindicate the plaintiff, which helps restore their reputation, and to dissuade others from publishing defamation statements or false light statements. If you find that any one or more of the plaintiffs' claims should be ruled in their favor, then you have to have the greater weight of the evidence, a preponderance of the evidence about the amount, not clear and convincing proof about damages, but in your deliberations, slightly more evidence in favor of the amount to award is the test, the burden of proof. Take into consideration all the facts and circumstances and evidence, decide what amount of compensation should be awarded to each particular defendant or plaintiff. These are the kind of types or examples for which you can award money. Harm to their reputation, including exposure to public hatred, public contempt, ridicule, or public scorn, and or loss of professional income and or out-of-pocket expenses, and or physical, mental anguish, pain, and suffering, loss of society, companionship, and friendship. Those are all eligible factors or categories by which to compare or measure damages. It could be that the award of damages is not easily determinable and you can't put an amount on it. You can still order what's called nominal, or I'm going to use the word token, damages. So if you find in favor of the plaintiff, then you have essentially the opportunity to go from 1 to wherever. Nominal or token would be the 1 or 10 or some low amount as a statement that they prevailed and entitled damages, but you're not bound by anything more than 1 in your deliberations. But if you find for a plaintiff, then there has to be an award for damages, assuming there's a causal link between the defamation or the false light and injury or harm to reputation, emotions, etc. As a matter of law, the court determined previously that the claimed damage to the defendant's home was permitted under the circumstances of serving the search warrant. Therefore, you do not make a reduction for any damage that the defendant said happened to his home during the search warrant. The court previously found, as a matter of law, that that's expected or permitted as a result of serving the search warrant. So you don't subtract based upon whatever you think happened to his home. In your deliberations, a plaintiff cannot have double recovery. If you find defamation and invasion of false light privacy, you don't issue an award under each category. You can't award pain and suffering, say this, emotional distress once and then emotional distress twice.
Yeah, so that was the, yes, scared. And one thing I want to say is that the lake has those brain-eating amoebas in it, and the abandoned Six Flags has one too. Quite freaky. Oh, okay. Yeah. Shout out to those emojis. I'm going to, something I was trying to do yesterday. I'm going to again, and let's see. Okay, good night, Moki. Okay, Moki, good night to you. See you at some point, perhaps on the stream tomorrow. All right, so Lori, I got so try to do what I was doing yesterday. Okay, this is the, so Lori, because we saw this for a moment yesterday, but yeah, this is the crawfish mound, and this is one right here. Okay, so yeah, these are those mounds we were talking about yesterday, and yeah, so they just walk. We've not seen any lately, especially with the weather, but yeah, those are the ones that like to walk around and be a little bit. See, like right there. That's what it does. Looks like a little lobster. They appear at random and usually towards the back. Lori said they call them chimneys. Chimneys, I think, too cool. I too may drift off for a cat nap, but I'll be listening just in case. Okay, all right, and that is perfectly fine. It is a. It's nice to have y'all here. And y'all call them mud bugs, Duke. Yeah, we're into the crawfish name. All right, and now, so although yesterday I told y'all that, I just wanted to finish my statement because I was literally like cut off right in the middle sentence. And right, no frog deek this time. We're just the crawfish and AFROMAN. All right, so you have that there, and X that window out. Yeah, they call them mud bugs in some places. All right, and now back to AFROMAN here. Let's see, and he talks. Yeah, crawfish pie. Let's see. I'm gonna look that up. Shout out to the spaceship cats. Yep, that's a. There you go. Yes, you were cut off when you're talking about the crawfish. Yeah, yeah. It looks good. Yeah. So, and the next one, I'll go into even more detail about the crawfish and some other things. So now continuing with this right here, and here we go.
You would issue one order as long as there's either a claim for defamation or a claim for false light, invasion of privacy. Don't double up if a plaintiff prevailed on both claims. Your verdict form doesn't really make that.
I had that before. Yes. I don't know when I had it. It may have been a little while back, but I did have it. It was a good crawfish pie. Also, I had lamb pie, but it wasn't really lambs in it. But we had that. So yeah, those were very good. Yeah, the crawfish pie is very delicious, and it's like pie, but it's like with why it has some other things in it too, like seafood. It smells like it's kind of like seafood in a pie.
Possible. You'll get there. We're getting close. Another concept that came up earlier was something called punitive damages. You are advised that punitive damages are not a part of the deliberations given to you right now. I haven't talked about punitive damages. Punitive damages are meant to be punishment damages for conduct. That's not a part of your deliberations. You're deliberating what we call compensatory injury-related damages. An award of punitive damages can only be given if there is a compensatory damage award. If a compensatory damage award is given, then you come back with a different set of instructions and you have arguably a second deliberation about punitive damage. You don't have to award it, but they aren't all lumped in. So don't think in this first phase, oh, the punishers are really mad. That's not where we are. If you find any plaintiff prevails on either claim, and it caused injury, compensatory, actual repair damages, if you will, are what we're here for, not punishment. That's a second deliberation. The verdict forms aren't that hard to understand once you know what you're doing. Each plaintiff has 3 pages. Page 1 is the claim for defamation. We, the jury, being duly impaneled, find in favor of, and then it says Sean Cooley or defendant, circle 1. So you have to circle whether the defendant prevailed on Sean Cooley's claim for defamation. Then there's signature lines. Regardless of that verdict, you go to the second claim. So the next form is we, the jury, find in favor of Sean Cooley or defendant for the false light claim. The instructions at the bottom of each page say, now go to the next page. If you find for that plaintiff on either of the first 2 forms, then you go to form number 3, which is damages. Damages is 1 line, where you put a number in. You can take notes and you can split it out, and you can do calculations, and you can decide how you get to it, but there's 1 line. So that would be for Sean Cooley, and it says Sean Cooley on the first 3 pages. And then the next 3 pages say Justin Cooley, same 3 pages. So the first 2 pages find in favor of that plaintiff or the defendant, circle 1. Next one in favor of that plaintiff or defendant on the second claim, circle 1 of those options. And then you go to the damages form only if the plaintiff prevailed on one of the first 2. They're all numbered, they all have names on it, they should be easy to follow. You can tell me later. What do you do when you go back there? The first thing officially you need to do is pick a foreperson. Now the foreperson's not the shop foreman, they're not the boss. They don't tell you what to do. The foreperson's job is to organize the discussion, engage people, keep track of the exhibits, be the committee chairman. But the foreperson doesn't convince you to do what they want, they organize the discussion. There's no way to pick a foreperson. You can arm wrestle, throw fingers, draw names out of a hat. Don't go to the bathroom first, because you very well could come out the poor person. I don't care. I've heard people say that. They pick them because they weren't there. It doesn't matter. I can't tell you how to pick one. Just get one. Throwing fingers is fine. It takes too long. You probably already know who's willing to do it, or maybe you've talked to each other enough, or you just say, sorry, you lose, you're it. But it's just organizing discussion. That's all it is. Just organize the discussion. Make sure nothing leaves. You'll have in your possession the verdict forms, the exhibits. You'll have copies of these instructions. Keep all that back there. When you come out, the only thing left to bring back out here should be all these verdict forms. Leave your notebooks back there. Everything else in the foreperson should make sure that that goes on. How do you deliberate? Generally, the advice to you is to go back there and start talking about the case, replay the witnesses, but don't just say, I think something ought to happen. Because when you come out with your first opinion and then start discussing it, a lot of people realize their first opinion is not their best opinion. But once you threw it out there, then you got to figure out, how do I get my pride back and retool? So generally, don't go back there and just say, here's what we ought to do. What do you think about this witness, and how did this one come across, and do you understand the rules? And start into this discussion process, however you can do it. But eventually, then you're going to need to start getting to the point where you see a consensus is being built. If you immediately express an opinion, changing is sometimes hard, so work together to build a consensus. Consult with one another in the jury room, deliberate with a view of reaching an agreement. You can do so as a group, but without surrendering your own conviction. Each of you ultimately has to decide this case for themselves in this deliberation process. You might find somebody leaning on you to change your opinion. That's good, unless you feel pressured against your will to change your opinion. If they come at you with good arguments, maybe you should rethink your position because their arguments really are good. So a certain amount of give and take and tension is usually the sign of a good deliberation. Just don't take it personally. Never surrender your own personal convictions just to get along. Don't be influenced by considerations of sympathy or prejudice. The law does not expect us to be robots and have no sympathy, no emotions, no prejudice, or no biases. That happens all the time. You have to set those aside. You're required to disregard them, to make your verdict carefully, to weigh the evidence, consider disputed questions of fact, apply the law to try to reach a verdict which the parties would be considering fair to both sides. Fairness is a big thing. Is this verdict fair to both the parties? Consider all the evidence regardless of who brought it forward. Do so with intelligence, impartiality, without bias, without sympathy, without prejudice. During the deliberations, if you have questions, you're welcome to write them down, which then comes to me, which goes to the lawyers to get you an answer. So like a magic doorbell. Knock on the door. Okay? The bailiff's like within earshot. He doesn't have his cup up against the door. So like pound on the door enough to get his attention. He'll come back, get the question, give it to me, I'll huddle with the lawyers, get you an answer. So when you get back there and there's a problem, you don't understand something, you want more information, you can get more information. Like we'll try to make sure you're not starving, like creature comforts will be provided, like we're gonna run into the lunch hour, so there's a way of taking care of it. I heard it yesterday, they'll do it today. So like we're gonna wanna cover all those bases. The clock is yours when the deliberations start. You watch me pay attention to the clock, right? I don't have a clock because you do. So how much time you need is up to you, not up to our expectations or our time commitment. We got to make sure that when you deliberate, you don't do so out of like human denial or fatigue. So yeah, we're going to watch to see how that goes. Like you might have me send you a question saying, is everybody fine? Are you awake? Do you need coffee? Do you need food? What do you need? One jury kept going, my personal record's 1:24 a.m. because that's what they wanted. If they didn't want to go home, they were not coming back tomorrow because they were locked in and doing a good job. But it wasn't my clock, it was theirs. Until the verdict is announced in open court, you cannot indicate to anybody what it is. When you knock on the door saying we have a verdict, the bailiff will come, he'll tell me that you have a verdict. The foreperson brings the forms out here, and you hold on to them till everybody's here, and then we open the verdicts in front of all the parties. Don't say, oh, so-and-so, and this is the outcome, because the bailiff doesn't want to know that, and he shouldn't know that, because it has to happen in this room. Up to this point, like I've told you, you'd like not to talk to people, that still applies. Anybody outside the jury, that's off limits. If we deliberate today, you went home tonight, came back tomorrow, the rule is especially important. You can't tell anybody anything at all. Once the case is done, you can, in case I forget to say that. With regard to deliberations, I've got 10 of you and 2 extras. So the 2 on the end, 17 and 19, you're alternates. So you don't deliberate, but you're not done. You're what we call insurance. There's no guarantee in an hour somebody's not going to get a call that they have to go, or that they hit the floor, or somebody had an accident, or the baby came early, or whatever it is. So you're not done. You're charged to not talk and to just wait. It's a luxury to have extras. I understand what I just did to you. I get it. But the number of times the jurors slot back in is not the majority, but it's enough that we're glad to have you for a reason. These folks get locked down and something happens along the way. We can't lose 3 days of trial work because somebody went through a stop sign or had a flat tire on a curvy road. Then all of a sudden you're back, we start all over, and the case gets done. So make sure the bailiff has your phone number. If you can be within like 15 minutes of the courthouse, I don't know what that means. If you live farther, just make sure Chris doesn't have to drive far to get you. He's not going to anyway, right? But he's big enough to, you don't want to cross him kind of guy. Anything you want me to deal with in the instructions, Mr. Klingler?
I had two minor issues.
Okay, we'll talk over there. Mr. Osborne, you got anything?
I do have something, yes, sir.
Okay, we're just going to see what I didn't do right. Well, we're close. Eight out of 8. So if you take a vote and it's 6 this way and 2 that way, that's enough votes. It does not have to be unanimous to prove a case. In a civil case, it's 6 out of 8. That a big deal? Yeah. Did I ever forget it? Yes. It's 6 out of 8. So you can have 2 people say, I don't agree, and if 6 people do, that's a verdict. And then the emphasis for the 2 alternates is not only not talking is important, but not talking to the media is important. So if you get hounded, it's anybody in the universe. Because you're still in the panel, and then if the jury reached a verdict without you, you're going to get a call saying, you're done, and now if you want to talk about it, you can. Anything else, Mr. Klingler?
Nothing from us, Judge. Thank you.
Mr. Osborne?
Your Honor, I just renew any objections for the record, but nothing else other than that.
Fair enough. Overruled. Or ruled, depending on what it did. There's a few typos. It'll be like 5-10 minutes before it gets you some sets of instructions. When you look at the instructions, if you have a question about something, read the whole paragraph, not just the one sentence. Like you always think, I want to know more about something. The answer might be 3 words, but read the whole paragraph to do it. So you start your deliberations. We'll get the exhibits back to you, cleaned up sets of instructions. And thank you for your attention so far.
When's lunch?
Yeah, are you taking our lunch order?
I sure am.
Take the key. I'm back in your house.
With you, yes. With you, I did. Okay, perfect. I appreciate it.
I think Mr. House, yeah, no, you're not going to? Okay, with Judge Spencer, Larry will be the judge. Okay. So, they just told me.
Relax, comfortable, have a seat, all like this stuff. So you know more than I know probably, but the jury's ready.
That's all I know.
That's all I know too. So process-wise is that they'll bring them out. The verdict forms go to me also.
You just want to move that note, don't you? Just wait until the judge starts to give it to him.
Okay, go ahead and have a seat. So the court was informed the jury reached a verdict, is that correct?
Yes.
Thank you. So if you'll hand the verdict forms to the bailiff, he'll hand them to me so I can take a look at them. I looked at the form of the papers, essentially to see if they're properly signed. So that's the next thing that happens. Thank you. With regard to decorum, I don't expect any responses from anybody. It's been an emotional case. It's been a well-tried case. The lawyers did what they should do. The parties did what they should do. I just want to remind everybody that how the verdict comes out isn't something of public comment. So if you have an emotional attachment to the verdict, don't express it. Wait till you get out of the building before you let your emotions out. So the verdict forms are properly executed, properly completed. Copies will be made available to the parties. In all circumstances, the jury finds in favor of the defendant. No plaintiff verdict prevailed. So the matter will be concluded with defense verdicts. Thank you, Mr. Klingler. Thank you, Mr. Osborne. Thank you to the court staff and the Sheriff's Department for security in the building. And we'll go ahead and stand in adjournment.
Thank you.
You're welcome. whatever it is you need.
Don't forget your phone.
Yep. Have the crew go that way. Have them go back into their room.
If you guys don't mind to hang out in there for a little bit, I can get you, okay?
All right.
Thank you, sir. Everybody is excused.
That's what we're waiting for. Literally, that's what we're waiting for. I was like,
The backstory of the warrant. That's the subject for criminal cases. So the fact that there's a search warrant is what this case is about, not the backstory of it. So we hear people talking about criticism of the why and the whole deal. That's not relevant testimony. We're living with there was a search warrant, nothing backstory. This case is not about excessive force in entering. The court's already determined as a matter of law that it was not excessive. You'll see testimony of damage, but that's a legal standard about whether it's more than customary or expected in the realm of a search warrant. Search warrants are lawful forced entry. So you won't get, was that too much force? That's outside the realm of the testimony. And I call these the third thing. This is not about vindication of the defendant or messaging to the public. That's things that happen from the political branches of government, the legislature, or the executive offices. Messaging is not what you're concerned with. It's the message the jury's sending. You're not messaging. It's all about how these facts affect these people. So when these little distractions and diversions come at you, I'm going to try to continue to narrow and keep you focused, not on the distractions, but on the issues and the law. Otherwise, you're going to ask later on, why didn't the judge give us instructions on messaging? Because that's not how this comes out. So I'll do this periodically along the way when things start going astray. Ready to go, Mr. Klingler?
Yes, Your Honor.
Tee it up.
Of course. Civil defamation case. It's not a criminal excessive force case. Of course, they're going to try to conflate it, hide behind the First Amendment. He has a right to say it, but if it's defamation, he has to deal with the consequences. That's the gist of it. Now, I haven't seen the stuff yet.
Raise your right hand. Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing
It
but
should
the
be
truth?
interesting.
As this you shall answer unto God.
I do.
Thank you. You can be seated.
Except you're a public official, you only expect to have your private residence address. Go ahead.
Thank you, Your Honor. Would you introduce yourself to the jury, please?
My name is Brian Newland.
And Mr. Newland, where do you live? No street address, just generally.
I live in Adams County, Ohio.
And how long have you lived in Adams County?
From 1995 to 2010, and then from 2015 to current.
What were you doing between 2010 and 2015?
I was in the United States Army.
Honorable discharge?
Yes,
What do you do for a living?
I'm a police officer.
And when did you start in law enforcement?
I originally started in law enforcement in 2014
And what position was that?
as a deputy sheriff
Where?
at the Adams County Sheriff's Office.
And then how long were you a deputy in the Adams County Sheriff's Department?
The Adams County Sheriff's Office was my first full-time job in law enforcement, and that was from 2014 until 2023.
All right. And why did you become a deputy sheriff?
After I got out of the military, I just wanted a job that I thought would be exciting, something different. So I chose law enforcement.
Do you have family here in Adams County?
Yes.
Can you tell us who?
All my family's here. My kids, my grandparents, my mom, my brothers, cousins, aunts, uncles.
Did your children go to school in Adams County, or do they?
Yes.
You were involved in the execution of a search warrant back in August of 2022.
Yes, I was.
And I want to take you back to the night of August 21st, 2022. Were you part of a team that searched Mr. Foreman's home?
Yes.
What was your role in obtaining that warrant?
I prepared the search warrant based off information I was provided, and then I met with the judge and the prosecutor at the time prior to serving the search warrant.
And was a warrant approved?
Yes.
Can you tell us where what the subject of the search was? The property of the search.
It was the residence of Mr. Foreman. I believe the address is 1699 Russellville Road.
Okay, that's here at Adams County, correct?
Yes.
Now, were the other plaintiffs here in the courtroom, were they also deputy sheriffs or part-time deputy sheriffs that participated in that search?
Yes, they were.
And was Mr. Foreman at home during the search?
No.
Were Mr. Foreman's children present during the warrant execution?
No.
Was anyone present other than you and your fellow officers?
At the time of arrival, no.
Was anything seized or taken from Mr. Foreman's home?
Yes, there was some money and a small amount of marijuana and some miscellaneous drug paraphernalia.
Why was the cash taken?
It's common with any type of drug seizure. We seize the money in cases proceeds from drug-related sales or drug trafficking activity.
Was money potential evidence?
Correct.
What was your role in seizing this cash, Detective?
I'm sorry.
Well, maybe I got ahead of myself. Was cash located in the property?
Yes.
Do you remember how much approximately?
Approximately $4,000.
And did you play a role in taking that cash?
Yes.
What was your role?
I was provided the cash or provided the money that was located by another deputy. I counted out the money, put it in an evidence bag, and then at the end of the search, I transported it back to the sheriff's office.
All right. Did you take any of the money?
No.
Did you ever take any money from the evidence bag?
No.
Did you ever take any of Mr. Foreman's money?
No.
Was your counting of the cash recorded on your body cam?
Yes,
And have you had a chance to review that?
I have.
Has Mr. Foreman accused you of taking his money?
Yes.
Are you aware that the cash was ultimately returned to Mr. Foreman?
Yes.
And can you tell us why that was?
The prosecutor at the time decided we're not going to pursue any crime criminal charges, and the property was released back to him.
Okay. Were you present when Mr. Foreman picked up the cash that had been seized?
No.
Do you know whether any press was invited to attend the return of this cash?
I learned that there was later.
Okay, but you weren't there.
Correct.
Can you tell us what happened when the money was returned to Mr. Foreman?
Your Honor, I would object to that. He's already testified he wasn't there.
Okay, let me rephrase it. That's fair. Was an allegation made that there was less cash than there should have been?
Yes.
And who made that allegation?
I believe Mr. Foreman.
How did you learn about this discrepancy?
The evidence technician at Lisa's property had called me and told me that the count was short.
Tell us what you mean by that. The count was short.
Just that there was more money listed than what there was inside, and that was less money was returned than what was indicated.
And where was this amount indicated?
On the bag.
On evidence bag?
Correct.
So I'm understanding you correctly. The amount of money that was indicated on the evidence bag was more than what was actually returned to Mr. Foreman.
Correct.
All right. And were you able to account for that discrepancy?
I wasn't. No.
What happened?
Once the allegation was made, the sheriff contacted the Claremont County Sheriff's Office to conduct an independent investigation.
Do you know whether an independent investigation was conducted by the Claremont County Sheriff's Office?
Yes.
And do you know the results of that investigation?
They were to determine that I miscounted the money during my original count.
All right. Did they conclude that any money had been taken?
They said that there was not any money taken.
Did that stop Mr. Foreman from continuing to claim you had stolen $400?
No.
Did he accuse anyone other than you of stealing money?
He, at multiple times, he accuses all of being thieves.
Do you know where he made these allegations?
Instagram, Facebook, YouTube, social media.
How did you learn about these accusations on the internet that you were a thief?
Friends and family were sending them to me.
Were the accusations true?
No.
That's nasty.
I think you said you've reviewed your body-worn camera from that night?
Yes.
And were you able to tell what happened?
From what it appeared as if I began counting money, I stopped to reshuffle money that was in my hand, and then began counting again after putting money down. And that was, at some point, there was a discrepancy in the amount that there was and the amount that I counted.
Was it a miscount?
Yes.
Now, were any charges ever brought against Mr. Foreman as a result of this warrant execution? I may have asked you that. I'm sorry.
No.
Sometime after the execution of this warrant, Detective Newland, did you become aware that Mr. Foreman had posted certain things other than being a thief about you on social media?
Yes.
And how did you learn about these posts?
Friends and family were also sending them to me.
Ms. Gratcher, could we see Exhibit 16?
Yes. We need to switch it to the other, to the HDMI. I'm right. Right, Chris? So if we, what is she wanting its card on?
She's and switched to left wall, I believe.
It's loud.
All right. We'll bring it on top up here.
Okay. You're gonna go to card.
Yes.
Okay, can we blow that up some?
Oh, that's bad. I would sue him too. And I like
right.
AFROMAN. I like the song. But you can't do this crap.
Detective Newland, we're showing exhibits.
It's one of the posts from Mr. Foreman that I was sent about me being a pedophile.
And am I reading the date right? September 2nd, 2023.
Yes.
And I'm not going to ask you to read it, but I will read part of it just to make sure it's in the record and that people are clear on what it said. This is the uneducated can't count pedophile police officer that stole my money. His name is baby making Brian, child molesting, newborn baby mama, newborn Newland, Detective Brian Newland. I have a song coming out about him. The chorus goes like this. I pledge allegiance to the flag. Brian Newland is a flag. He used to play with little toys. Now he plays with little boys. Watch your little boys around Brian Newland. He's very bold. He will fondle little boys' testicles and butt cheeks right in front of you in broad daylight. This is a public service announcement. Stay safe. Did I read that correctly?
Yes.
Can we see exhibit 17, please? Can you just scroll down so we can see the whole thing for a second? All right. So I'm not going to read this whole thing, but it says in part, if you pay me back the money you stole from me, I won't tell the world about your pedophile pilgrim family, you know, like your brother, that's named Will You Stop Sending Dick Pick Williams, AKA William Newland, if you get arrested in Abbs County, all you got to do is lie on me and Brian will let you go. And is that a picture of your brother beside your picture?
Yes.
And was your brother convicted of a misdemeanor?
Yes.
What was that?
I don't recall what the charge was.
It was a misdemeanor charge.
It was a misdemeanor, correct?
Did you have anything to do with that crime?
No, I did not.
Have you ever been accused or convicted of pedophilia?
No.
Let's look at, let's see, number 18. Is that a video?
Yes.
All right. Shall we play the whole thing? Or what do we have, a clip?
Yes.
Why, yes. Baby making Brian newborn Newland. Yeah, the serial statutory rapist with the pedophile brother fired from the People's Police Station. Will you stop sending Dick Pick Williams?
All right, and let's take a look at number 10. Is this a, yeah. Okay. Let's see. He used to do hard drugs. It says there in the third or fourth line. Did you ever do hard drugs, Detective Newland?
No.
He snitched on all his friends. Do you have any idea what that's all about?
No.
Now he steals money from traffic stops, bogus raids, and from Adams KK County Sheriff Evidence Room under the camouflage of law enforcement. Did you ever steal money from a traffic stop?
No.
Did you ever steal money from anybody?
No.
Then down below it says, baby making Brian Newland t-shirts on sale. You see that?
Yes.
Let's look at Exhibit 15, please. And can you tell, Detective, is this a picture of you at the entering the or somewhere in the property of Mr. Foreman during the search?
Yes.
And let's take a look at 14. And do you know where this was taken? I guess you weren't there.
It appears to be the inside of the interview room at the Adams County Sheriff's Office.
Would that have been where his money was returned to him?
Yes.
And part of what it says is, when I went to get my money and we realized baby making Brian newborn Newland had stolen $400 out of the evidence money. Again, did you ever steal any of his money?
No.
Let's take a look at Exhibit 15, please. Or did we do 15?
Yes.
Sorry. Number 2. Okay, oh, I'm sorry.
Objection.
Yes, Your Honor, I would have an objection to this video.
Tell me what it is.
Your Honor, this objection is video because this video, if I'm not mistaken, was published within the last 2 weeks. The law on this has changed. Ohio has actually passed what's called an anti-SLAPP law, which therefore extends immunity to things, actually, in a way, increasing a person's freedom of speech rights in Ohio. Thus, this evidence to be tried here would be tried under a completely different standard than when this case was started.
Comments? Mr.
That law doesn't apply to this case, Judge, or this evidence.
Your Honor, it would apply clearly. He has no analysis other than say that I submitted a written brief to the court on this matter.
I think that was submitted Sunday.
So, like, I'll note the objection, overrule it, and allow it to be played. Got your objection down. Thank you.
Thank you, Judge. Can you expand it a little bit or not?
I cannot.
So we can see the sign? Okay. Detective Newland, can you see what that sign says?
Yes,
What is it? Could you read it for us?
they stole my money.
Okay. Go ahead and play.
Videos selling my proof. How can you take me to court when you stole my money and it's $400 short? You vandalized my property, and you filed a lawsuit properly. I'm a rapper, so I'm rapping. What? I can't talk about what happened. Videos I exposed my
So what does that say? Sorry. What did you read? Could you read what that said?
Yeah, Brian Newland stole my money.
This
Brian
is
Newland stole
wild.
my money. And that was just published in the last few days, as far as you know?
Yes.
Can we look at number 3, please?
but telling the truth and the truth. Posting videos, selling my proof.
Okay, basis.
Same basis on, yes.
No.
Thank you.
Go ahead.
Can you take me to court when you stole my money and it's $400 short? You vandalized my property,
I think that's enough.
lawsuit properly. I'm a rapper, so I'm rapping. But I can't talk about what happened. Videos I exposed my cause.
And that was the same video, obviously. Does it tell where that was posted?
It looks like this one is on YouTube.
And the other one was Instagram?
Yes.
So 2 different platforms, same video.
Yes.
And can we look at Exhibit 9, please? And I'm looking specifically about halfway, a little more than halfway down. Do you see, Detective, where it's posted, not only did he steal my money from my house, he stole money out of the evidence room at the Adams County Sheriff's Department away from my house, making the Adams County Sheriff's Department a new crime scene. I'll just stop there. Again, did you ever steal any money from his house or from the Sheriff's Department evidence room?
No.
What's the platform?
Can you see what that one was, Detective?
I can't see on here.
I don't make any of the songs. But my people can do better.
Is that Facebook? No.
What?
And we can take that down or whatever. We don't need to keep it up. I don't care. But I'm done with the exhibits right now. Detective, I just want to ask you, the first one we saw with you holding, it looks like a child with a smiley face.
Yeah.
What was that originally a photo of?
That was from one of the shop with the cop events at the sheriff's office.
Well, what's a shop with a cop event?
It's where the community donates money, and then local law enforcement will take lower income children to Walmart and let them shop for Christmas.
And did you participate in that event regularly?
Yes.
And do you know what year that picture was taken from?
I don't recall.
All right. And the little boy you were holding there, can you tell us anything about who that was? Not his name, of course, but who it was?
Just a cool little boy that got picked for Shop the Cop and chose me to be his officer.
Chose you to be what?
His officer.
And what did you do? Did you do something with him, shop with him, or what?
We put him in the cruisers, turn the lights and sirens on, parade through town, and we go to Walmart and help him shop. And we come back to the fire department or wherever and help them get their toys ready or play or, and feed them pizza, stuff like that.
And you did that more than 1 year?
Yes.
And that was a photo that Mr. Foreman or somebody on his behalf took and used in that pedophile posting?
Yes.
So
That's the whole problem right there. Colleen, you nailed it.
What effect did it have on you when you saw these posts that you're a pedophile?
I was angry, sad, depressed, upset.
Why were you sad or upset? Isn't it just somebody exaggerating or making jokes or making a comment?
I didn't find it funny at all. I work in law enforcement, have kids, have friends, family. I was involved in the schools. And then I'm being blasted all over social media for the entire United States to see that I'm a pedophile.
Did you ever have any evidence that other people were seeing these things other than the fact that it's on social media? Did anybody ever say anything or do anything to indicate they'd seen it?
I've had comments made to me since day one.
Like what?
If you want the most recent example, yesterday there was a cheer competition at North Adams. I walked my 3-year-old son in to watch his sister cheer, and somebody asked me if that was another little boy I'm touching.
Yesterday?
Yesterday.
Where? What competition?
At the North Adams cheerleading competition.
What other examples?
Every time you go to an event, another comment's made or somebody says something. Another one I can recall is meet the team night for my daughters. We was in line to get slushies and people were making comments behind me.
What comments?
Just called me a thief and a pedophile and why was I there? And then started playing some of his songs on their phones.
Some of Mr. Foreman's AFROMAN songs?
Yes.
This case isn't about your kids. They're not plaintiffs, but did this have any effect on your kids that affected you in turn?
Your Honor, I'm going to object to this. We had a motion, I filed, and never responded.
He goes better than to ask a question because I don't care about the kids because he didn't bring the kids in, so sustained.
What other indications have you had, Detective, that people are seeing and responding to this accusation that you're a pedophile?
Just what's been said to me. It's been shared, been sent to me. I've had people make comments at games while in the store. It's just
You got the evidence for that, Griggsy?
So you were a Hamilton County deputy sheriff. Sorry, I said that earlier. You were an Adams County deputy sheriff, and you're not anymore?
Correct.
Why?
I ended up leaving the sheriff's office just because of this, because of being called a pedophile and a thief.
Explain to us just a little more about why that was so upsetting that you actually left your job.
Because the sheriff's office, so I'm from Adams County, is where all my family and friends are from. The sheriff's office was my dream job, my position. I was friends with everybody, and it was where I planned to stay. It's been my career. I dedicated a lot of time, over 10 years, to Adams County. Whether it was calling at 1 o'clock in the morning or working 14 hours, I dedicated a lot of my time to Adams County, and I loved working at the sheriff's office. But it just got to be so much. If you go to a call or take a phone call or you make a traffic stop, something said. You go to Walmart, something said. I stopped going to my kids' games for a little bit because every time I would show up, everybody would be looking at me or something would be said to me. It just spared their embarrassment.
So when did you leave the sheriff's office?
I ended up leaving in October of 2023.
You have Do your kids' friends come to your house and hang out?
They don't anymore.
Did they used to?
They used to have huge slumber parties, especially on their birthdays. They'd have 10 or 11 kids over. And essentially, once this started, it stopped. I don't recall the last time my daughters have had a friend over, if they've had one ever since then.
Detective, did you ask Mr. Foreman to take down these posts?
I didn't personally.
Did you through your attorney?
Yes.
And have they been taken down?
No.
Are they still there?
Yes.
Those are all of my questions. Thank you.
Is this a good time for a 10-minute break?
Yes.
Then we'll do that. Off the record, take a 10-minute break. Thank you.
You were asked questions about a search warrant. Is it correct to say you were the chief in charge of executing that search warrant?
Correct.
Okay. And you counted all the money?
I did.
You had full control of it the whole time?
Not the entire time, no.
Okay. So walk me through the process by which you cataloged the money.
So while we were conducting a search of the residence, another deputy located the money, I believe, in a jacket pocket from a suit.
Okay.
He handed me the money, explained to me where he found it. At that point, I start to count it in the same room. Once I count it, I collect it, put it in Evan's bag, and take it downstairs.
Okay. So let's back up. That was very general. So when you counted it, where did you count it?
I counted it in the bedroom where it was located.
And you counted it on the floor?
Yes.
Okay. And you made specific piles?
Yes.
Okay. Now, that's not all the money that was recovered is what was coming out of the suit, right?
Correct.
Where was the other money recovered?
There was more money covered from, I believe it was an office downstairs.
Okay. And where did you count that money at?
In that room.
On the floor?
I don't recall if it was on the floor or maybe on a desk that was there.
Okay. And you were wearing your body cam the whole time?
Yes.
What was the time difference between the suit jacket money and the money downstairs?
I don't recall.
You reviewed your body camera?
Yeah, it's been a year. I reviewed it over a year ago. I don't recall what the time frame was.
Well, Mr. Newland, let's ask that question. You were deposed, correct?
Yes.
You were deposed on August 8th of 2025, correct?
Correct.
Have you watched the body cam since then?
I haven't. Well, I take that back. I've watched pieces of it. Haven't watched the entire thing.
What pieces have you watched?
Just of me recounting, of me counting the money from the bedroom.
You watched only the part of your body cam where you recounted the money in the bedroom only.
Correct.
You never watched the part for downstairs.
I did not.
You never watched the part where you sealed the evidence bag.
No.
Did you seal the evidence bag?
The evidence bag was not initially sealed, no.
What do you mean by initially sealed?
So it's not a self-sealing bag. It has to be taped.
Mhm.
So it was placed in an evidence bag and then brought downstairs to a central location until it was transported to the sheriff's office.
And the central location, where was that?
In the kitchen?
And you left it there alone?
No.
Who did you leave it with?
When I first brought it downstairs, Officer Cooley was sitting at a counter and I asked him to keep an eye on it while I continued the search.
Okay, and did he keep an eye on it?
As far as I know, yes.
What do you mean as far as you know?
I mean, I wasn't there the entire time. I went on to continue searching the residence and come back down.
But wouldn't he be in the chain of custody?
Yeah.
So did he sign the evidence bag?
No, I didn't. He wasn't in charge of the custody in that sense of signing or sealing the evidence bag. I just brought the cash down while we was still conducting a search and asked for him to keep an eye on it.
So the cash was never left alone?
That's my knowledge, no.
Were you interviewed by a Mr. Robinson in relation to this matter?
No.
Okay. Did you make a report about the missing money?
I didn't know.
So there was this question about a return on a search warrant. Can you explain what that is?
The return?
Yes.
It's just an itemized list of properties seized from a location during a search warrant search.
Did it include an amount of money seized on it?
Yes.
Does that amount of money match what was written on the evidence bag?
Yes.
So as far as the court knows, there was more money taken than what was returned?
I'm sorry.
So as far as the court knows with the return, more money was taken than what was returned.
That's the way it appeared, yes.
Did you put in an amended search warrant return?
I don't believe so.
So you never corrected your statement to the court?
Correct.
Okay. Does the Adams County Sheriff's Office have a policy and procedure pertaining to the counting of money as evidence?
I believe so.
What do you mean you believe so?
I haven't worked there in almost 3 years.
Well, before you worked there, did they have one?
It was, I don't necessarily know that it was a written policy, but it was to have 2 people count the money.
Did 2 people count the money?
No.
Oh, man, I'm confused on that. Can you tell me why?
So explain to me why it matters, like where you're going in this case's context. Tell me why it's relevant.
Your Honor, this is relevant because if the evidence of Mr. Robinson is admitted, which he has not been here yet, but if it is admitted, this would be direct evidence since he did not interview the person who counted the money. This would go to counter Mr. Robinson's report. And actually in my motion in limine, I talked about it in the idea that we did not have time to depose Mr. Robinson to determine what his investigation was or who he interviewed. As such, I'm asking a leading question of Mr. Newland because he didn't follow the policies and procedures. This was not taken into account by Mr. Robinson, and Mr. Robinson has made certain conclusions in his report that this would tend to cause issue with.
Mr. Robinson on your witness list?
Mr. Robinson is listed on Mr. Klingler's witness list.
Is he going to be called?
Depending on what happens, you might be.
Like, my concern is going to be hearsay. And everything you're asking the wrong witness is in that category. I get what you're doing. I just try to follow the trail of breadcrumbs.
I'm afraid I'm not understanding the hearsay argument, Your Honor.
He's going to say what another person said and observed. Didn't see it, but read about it or doesn't have it firsthand. He already said he wasn't involved in that part of it. I'm going to give you some room to work.
I have moved past that. That's where I was talking about the policies and procedures, which would not be hearsay in the idea he should know.
No, I get that. I'm just trying to track where you're going so I don't miss the ship sailing. Go ahead.
So, Mr. Newland, you worked at the Adams County Sheriff's Office from, what was the date on that? 2014 to 2023.
Yes.
During that time, when you started the Sheriff's Office in 2014, you reviewed the policies and procedures?
Yes.
So you would have seen the policy on counting cash?
If there was one at the time, yes. I don't recall.
So you don't know if there was a policy at the time?
Correct.
Okay. So how do you know it was supposed to be counted by 2 people?
That was the practice that we normally adhered to. It would be counted by one and then recounted by a second.
Okay. And the second person would initial the evidence bag?
No, it was just kind of like almost like a system of checks and balances. And then the seizing officer would still instill the evidence.
This may sound an extremely stupid question. How many times did you count the money?
I counted it one time.
Why only once?
At the time, there was so much going on. I counted the one time, put it in the bag, and until we got done.
Okay. So when you retrieved the bag, you never counted it again?
Correct.
Okay. Did you seal the evidence bag before you left?
I did not.
Okay. Did you seal the evidence bag at the Adams County Sheriff's Department?
Yes, it was sealed at the Adams County Sheriff's Office.
I didn't ask if it was sealed. I asked if you sealed it.
Yes, I would have sealed the bag.
Back to the deposition of August 8th, 2025. Do you remember that day?
Yes.
Do you remember I asked you about the money?
I remember their conversation about the money, yes.
Oh. Do you remember I asked you if you sealed the evidence bag at that time?
I don't recall you asking that.
Really? Okay. Did you ask the sheriff to do an investigation on the missing money?
I didn't know.
Okay. So I just want to get something clear here because my notes are a little fuzzy. You were in the Army at the same time you were a deputy, right?
So, yes, I was in the reserves at the time.
Okay. So that's why you would have been a full-time deputy in 2014 and then discharged honorably from the military in 2015?
Correct.
Okay. You said this job was exciting.
Yeah.
What do you mean by exciting?
So, like I said, when I left the military, I wanted a career that would be not mundane, but kind of like an exciting, something new type of career. So I chose law enforcement.
Okay. And you've been called derogatory names before, correct?
Yes.
Significant derogatory names, correct?
Yes.
And that's by members of the public, correct?
Yes.
And that was prior to 2022, correct?
Yes.
Now, you mentioned you have some brothers. Do you have a brother that worked in law enforcement?
Yes.
Was he the chief of Peoples?
He was.
Police? Why did he leave?
Why does it matter?
Your Honor, it has been brought up because one of the images has William Newland, and as you read through the post actually talks about Mr. Newland leaving the police department, so therefore I am building a foundation to show the truth of what statements are in there.
Is that the reference to the plaintiff's picture he was talking about?
It's a reference to one of his exhibits, yes. Give me a second, I'll tell you which exhibit.
As long as it refers to that exhibit, I get where you're going, so you can keep going.
Okay. I'll re-ask the question. Why did your brother leave the People's Police Department?
He was charged with some kind of crime through the Adams County Prosecutor's Office. He was subsequently convicted, and he resigned or quit sometime during the process.
And it is a fair statement to say it involved minor children?
I really don't know anything about the investigation.
You don't know anything about your brother's crime he was charged with?
Just what I've seen on Jail Tracker in the past.
So you're not close to your brother?
I'm not, no.
Okay. Are you close to your family then?
Yeah, most of my family.
Then why not your brother who's in law enforcement?
Well, we were both in the Army at the same time, separate parts of the world. We kind of got close again, and then once this, his issues happened, we kind of just drifted apart again.
So you drifted apart once he had a criminal problem?
Correct.
Okay. Now let's talk about that. Has anybody asked you about that prior to 2022 when he was charged?
No.
No one asked you about your brother?
I'm sorry. Before he was charged and it came out to everybody? No.
So no one asked you about your brother being charged with a crime?
Yeah, after the fact. I've been asked about it.
When was the first time you were asked about it then?
It would have been shortly after he was charged or arrested.
Okay.
It was all a complete surprise to me.
And that was prior to Mr. Foreman's video and post, correct?
I believe so, yeah.
So now you've said people have treated you differently since Mr. Foreman's post.
Yes.
So people come and ask you about your brother. Did they treat you differently because of that?
It was just on a smaller scale. I was asked about it, and then that was it. It wasn't shared, and I wasn't put in music videos and everything else because of that reason.
But your brother's criminal charge and everything was in the front page of the local newspaper, correct?
Yeah.
So everybody in Adams County knew that your brother was charged.
Correct.
And so did people treat you differently at that time?
No.
Not at all?
No.
Why didn't they treat you differently?
That'd be a question for them.
Okay. Would it be because they knew you?
Since he said he doesn't know, you shouldn't ask that question. Strike it.
We'll strike the question and move on.
Thank you. See, that would be a classic example of testimony from the lawyer, not the witness who said he doesn't know. Go ahead.
If you don't know if they treated you differently when your brother's was on the front page of the paper, how do you know that your treatment today, or as you've testified to, was due solely to Mr. Foreman?
Well, prior to this, nobody called me a pedophile. Prior to this, there was nothing published about me being a pedophile. Prior to this, nobody asked me if I was molesting my own 3-year-old son.
What about the officer? Let me rephrase the question. Did the officers that you work with at Norwood put up a picture or an image of Mr. Foreman on your computer?
Yes.
Did you ask them to take it down?
No.
Did they think it was funny?
Yes.
And they're in law enforcement?
Yes.
Do they think any different of you because of this?
I don't know.
They don't treat you differently?
I don't really, I mean, I work with them, but I don't really associate with them. I go there and I do my job and I come home.
When you interviewed for the Norwood Police Department, they never held anything Mr. Foreman said against you?
I don't believe so, no.
Okay. Would it be fair to say it did not affect your professional career then?
Oh, it absolutely did.
How so?
Even if I move locations from Adams County to Cincinnati or to Los Angeles, people still ask if I'm a pedophile. People still ask me what it's about. People still ask me if I'm a thief.
But the people you work with do not ask that, correct?
They don't ask me, I know.
When you were interviewed, your future employer never asked you that question.
No.
So then when you say it damaged your reputation, you're only referring to people in the public, correct?
No. That's just what people in the public is what I know. Maybe people do have bias against me, in law enforcement. I don't know.
Okay. Were you ever passed up for promotion because of this?
Not that I'm aware of.
Okay. Were you ever disciplined because of this?
No.
And you agree while you're out in the public, people are seeing you perform your law enforcement duties?
Yes.
And based upon what they see, they will make comments about you, correct?
Yes.
So how you perform your duties reflects on your reputation?
Yes.
And you've testified in the courtroom before, correct?
Yes.
Okay. Have you ever testified in a civil case before?
No.
Have you ever testified in a civil case that involved the duties of a police officer before?
No.
Okay. You've had citizens comment on your execution of your duties before, correct?
Yes.
Not all those comments have been positive, have they?
Correct.
And so you would agree that as a police officer, you are subject to public scrutiny?
Yes.
And you've never sought to keep your status as a law enforcement officer secret?
No.
Have you ever been in a local newspaper?
Yes.
Was it positive or negative?
Positive.
Okay. But not everything they write is positive, is it?
Correct.
As you've said that people can comment on your execution of your duties as a police officer, did you follow the procedure correctly in execution of the search warrant?
In the execution of the search warrant itself, yes.
Okay. So you knocked on the door as required by law?
Correct.
Okay. And then you decided to kick it in?
Correct.
And then when you couldn't kick it in, you went to the side door with a battering ram?
Correct.
Why did you try to kick the door in with your foot?
Is this what we're not trying?
Your Honor, he has opened the door and saying that his.
No, I closed the door. So I don't think we're trying the search warrant case.
Your Honor, he is claiming that his reputation is linked to how he performs his official duties. I am merely introducing that he has not followed procedures, and therefore a person can criticize him on that, and therefore he would have that as part of his reputation that everybody would have to consider.
We don't have any standard against which to measure that, which is the whole point.
Mm-hmm.
So how are we going to get a standard against which to measure that? Otherwise, you get a dance in the pea patch. I said we're not dancing it.
If we can't present that he hasn't done his job correctly and that would reflect negative on his reputation, then I don't understand what we would be presenting that, because his reputation is exactly what he is claiming is damaged. It is the very issue that they're going to ask for money damages about.
Do you have an expert that's going to say there was a violation of a search warrant process?
No, we're just going to introduce the policies and procedures in place at that time.
There are some?
There are, yes.
Well, then put the foundation out there first. Like my prior decision, made that clear. I'm trying to work with you, don't get me wrong. I'm pretty good about staying laser focused.
I'm trying to ask the questions now so I don't have to recall Mr. Newland after the sheriff, Kenny Dick, is called, so he can tell us what the policies were at that time. But I can say this line of question and recall him later for it if that
Seriously?
would be more amenable to the court.
We have a sheriff named Kenny Dick in this case? We can't.
I don't see policies and procedures on your witness list.
The witness list or exhibit list, Your Honor?
It's all together, so exhibit list, I might have an old one.
There is an amended one, if I may, Your Honor.
You have one, Mr. Clinton?
Yes.
Amended when? Mine's dated March 12th, so if you amended it on Friday, I might be out of date.
March 12th. Okay.
I have an amended witness list. I don't see Sheriff's Office policy and procedure.
Policies and procedures for Adams County Sheriff's Office.
So that's is it the whole policy procedure manual?
Yes, Your Honor, although we're going to try to tailor it to.
There's no prosecution. This isn't a criminal case. There's, I guess, prosecution of the plaintiff's case, but you don't call them prosecutors.
I would note I would need Mr. Dick to come in and say they were in place at the time, as Mr. Newland can't remember that they were in place at the time.
We might get to stick it.
I need Mr. Dick. How many times have I heard that?
Now, it's not every time you're in public that people yell and scream thief or pedophile, correct?
Correct.
There's quite a few times you can have a peaceful meal with your kids and never have any problems.
Correct.
It's only at certain times this occurs, correct?
Correct.
Okay. Have you ever been accused before of stealing money from traffic stops?
Yes.
It was not Mr. Foreman that accused you, correct?
Correct.
Okay. Have you seen a copy of Mr. Robinson's report?
I may have seen, I don't believe I've seen the whole report. When he first conducted the report or conducted the investigation, I was provided a copy of the report or a partial copy.
Okay. But you never sent that to Mr. Foreman, did you?
I didn't know.
Okay. You would agree if someone called someone a baby killer, that would be an exaggeration?
I'm sorry.
If someone called someone a baby killer, that would be an exaggeration, wouldn't it?
Yes.
Nobody would take that seriously, correct?
I'm sure somebody would.
So when you talk about your reputation, are you talking about your reputation only in Adams County, or are you talking about it in the whole world?
My reputation in general. Adams
And what-
County, Hamilton County, the entire world.
The entire world. So you care what people think about you in Australia?
When it affects me and my job, yes.
How does Australia affect your job?
Hell yes.
I'm not saying that it does. I'm just using it as a generalization. If it affects me and my personal life and my job, yes, it matters to me.
What? What a stupid line of questioning.
Now you're claiming that by being called a thief, you were painted in a false light.
Yes,
And what exactly does that mean?
that I was being painted in a false light.
You've been accused of stealing from traffic stops before.
So being accused of stealing in traffic stops before was when money was seized and forfeited by the courts and no longer returned. And I was, unquote, quote unquote, called a thief.
Okay.
Never to this extent.
Okay.
Never to this broad, you know.
But you would agree there is some similarity here. Money was seized here too.
Correct.
Okay.
In law enforcement circles, that as you've experienced it, and the attitude toward therapy and emotions and that sort of thing?
There's a stigma on seeking medical help or seeing a doctor or taking therapy. You just expected to take it and move on, you know, and it's all fun and games, kind of like, you know, them posting that picture on my computer. I didn't find it funny at all, but they did. Like, it's just that stigma, you know, around law enforcement in general.
So you've been dealing with this by yourself, as you say, without medical help?
Yes.
Those are all my questions, Judge. Thank you.
Thank you, Ms. Osborne. Thank you.
Thank you.
I hope I have all this in the right order. I did the best I could. If I have it wrong, tell
A few
me.
more questions, Brian. You would agree that there was mistakes made during the search and counting the money and everything, correct?
Yes.
So it was
The
not done
conjugation
perfectly,
camp.
correct?
Correct.
Now,
You mentioned that as an officer, you're supposed to take it and move on. Is that part of having a thick skin as a police officer?
I guess you could word it that way, yeah.
Is it correct to say that the officers at Norwood found it funny, but you didn't?
Correct.
So some people find things funny that you don't find funny?
Yes.
Your Honor, I have no further questions for this witness at this time.
good.
I'm gonna step down. What do you got that's gonna get me 30 or 40 minutes? Mr. Klingler?
Our next witness, Judge, is Lieutenant Lisa Phillips.
Can you get through your direct by 4:15 to 4:30?
That may be difficult.
Then give me somebody you can get through.
I want to know if AFROMAN's going to testify in this thing.
I think I can get through my direct, Judge.
That's the goal. Thank you. Let's go.
Do you solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? As this, you shall answer unto God.
Yes, sir.
Thank you.
You can be seated.
Go ahead, Mr. Klingler.
Thank you, Your Honor. Would you introduce yourself to the jury, please?
Lisa Phillips,
And Lisa, where do you live?
Adams County.
How long have you lived in Adams County?
At least 24 years or so.
And what do you do for a living?
I'm a deputy sheriff.
When did you start your career in law enforcement?
2001.
And what were you doing at that time?
I graduated high school in 2000 and went to the police academy.
Well, what academy did you go to?
Greenfield Police Academy in Hillsborough.
And how long have you known you wanted to be a police officer?
Since I was a kid.
What was your first position then out of the academy?
Part-time at West Virginia Police Department.
And then when did you was your next job a deputy sheriff?
Yes, sir.
When did you start as a deputy sheriff?
September of 2002.
And do you have family here in Adams County?
Yeah. Yes.
Do you have a husband?
Yes, sir.
You have a child?
Yes, sir.
How old is your child?
She's 21.
And did she go to school here in Adams County?
Yes, sir.
Do you have other family in the area?
I got grandma and cousins and family like that.
And did you ever serve as a school resource officer?
Yes, sir, I did.
Tell us about that.
I took the job full-time at the sheriff's office as a school resource officer. Is what I started off as, deputy sheriff, school resource officer. Then was there for the kids, keep the kids safe, out of any kind of danger. I also was there for the kids, as far as, bonding with the kids, keeping them, as far as like way of life, just somebody else to be there, Sometimes they need somebody to talk to. I did that quite a bit.
And did you sometimes greet the kids when they got dropped off at school?
In the morning, I directed traffic at the school.
And
Yep,
did you
I'm
have
staying out of that.
occasion to know any of Mr. Foreman's children?
I don't know him by name, but I have let him out of the vehicle before, or not let him out, but
Nailed it.
him. I was called.
And is that part of your job? Even if you're off duty, if you need to be called in for something, you drop everything and go do it?
Yes.
Was Mr. Foreman home during the warrant execution?
No, sir.
Were any of his children present?
Not initially.
Did you see any of his children that night?
In the vehicle with their mother.
Just to clear that up, can you tell us what happened?
Come in the driveway, and I was on the outer post of the house as far as like the perimeter area. And she pulled up with the kids, and I went over and spoke with her, and I told her we probably wouldn't be good for the kids to see us, so they wouldn't be there to
Do you know
be
whether
upset or anything.
Excuse me. Do you know whether the children live there or do they live somewhere else?
They live up the road. Up down the road from there.
With their mother?
Yes.
So then did they leave or did the children never went into the house or anything?
No, sir.
Did you take any money that night?
Yes, sir.
Sometime after this warrant was executed, did you start becoming aware of things Mr. Foreman was posting about you on the internet?
Yes, sir, I did.
We have some exhibits that we want to show you. Do you have them lined? Do you have them lined up, Natalie?
I have them pulled up,
Okay.
they won't play, but.
Yeah. Let's go to the first one. Is that the order that we put them in?
I have the order.
Okay. Which number is this?
This is number 19.
Thank you. So Lisa, we're showing you what we've marked as Exhibit 19. This looks like a post from September 17th, 2022. Was that shortly after the execution of the warrant?
Yes, sir.
Can we blow it up just a little bit? Okay, down. Near the bottom of that first paragraph, just go down a little bit more, right there. Has anybody in Adams County verified her vagina? If you haven't, you should, or she might.
That's not funny.
Whoop out something bigger than yours.
This is not funny. I repeat,
If this lady is your
funny.
friend, I wouldn't leave her alone in my house. Or I'll put it this way, if you leave and your video system is messed up, et cetera, and then down below a little further, my name for this particular officer is Lieutenant Mona Lickamlow Lisa. When did you first see this posting, if you recall?
Shortly after the warrant.
That was over three and a half years ago. Is that
Yes.
right?
Yes, sir.
Let's go to the next one. And you see here, it says disconnect after stealing my money.
What's the number?
Sorry,
20.
exhibit plaintiff's 20, Your Honor, thank you. Is suing me for humiliating her, giving her mental stress, ridicule, and the loss of her reputation. She doesn't like being called Lieutenant Mona Lickamlow Lisa full of shit Phillips, but she loves stealing money and disconnecting cameras of law-abiding, tax-paying citizens. That's March 25th of 2023, is that right?
Yes, sir.
Go to the next one. Which number is this?
Number 21, and it's a video.
Okay, and this is the background behind me is based on the planet Serpo, which is a conspiracy theory of I think I talked to you about before, a planet out somewhere, in space that aliens are in. And yeah, take care, Max. And at this point, see y'all later on the Garden Live, and good night, everybody. Thank you all for watching this recap on AFROMAN trial, and peace. There we go.